Hello friends, in the series on the income tax cases, today we will discuss a case which is based on the opportunity of cross-examination in a case where the assessment of the assessee is going to be finalized just on the basis of statement of some persons. The question before the tribunal was that if the addition is done in spite of assessee being repeatedly asking the opportunity of cross-examination of the person on whose statement the addition is going to be made. If this opportunity is not being given to the assessee, then what is the fate of the additions? This issue has been taken by Chennai ITAT C bench in the case of Aragounder Muthusamy versus Income Tax Officer, and this case has been reported in 114 ITR Tribunal Short Notes 47. The date of the judgment is 9th August 2024. The facts of the case are very interesting. In the medical colleges, it is a very routine practice that the admissions are being sold to the various persons by taking the heavy capitation fees. And it is also a general practice that this capitation fees is being taken by the medical colleges in cash. In the like way, in the present case, there was a medical college S. There was a search by the revenue on this medical college, and simultaneously search was done on the director of the college. The director in the statement recorded in the search admitted that the college has received capitation fees from the parents of the various students, and this capitation fees was to a magnitude of rupees 50 lakh. On the basis of the statement of that director, the notices under section 148 was sent to the present assessee, and the assessee was asked to explain that why the addition of rupees 50 lakh should not be done in his hands as an undisclosed and unaccounted money. The assessee was repeatedly requesting during the assessment proceedings and denying that I have not paid this amount, and the assessee was saying that the assessee should be provided the opportunity of cross-examination of the director of the medical college, who is saying that the assessee has paid the amount of rupees 50 lakh as capitation fees in cash. But the assessing officer denied this opportunity and very conveniently being remained silent on this point. The assessee asked for directions under section 144A, which talks about of power of the joint commissioner to give the direction in certain cases, and the assessee also requested in the assessment proceedings that the joint commissioner should take and consider the request of the assessee to give the opportunity of cross-examination, but even the joint commissioner also did not take the heed to provide the opportunity of cross-examination to the assessee of the director of the medical college, so that the assessee can cross-examine that person, that how the assessee has given the cash to that person or to the college. The learned assessing officer went away with the huge addition of rupees 50 lakh, and when this matter came to the CIT appeal as usual upheld the order of the assessing officer. The assessee has no option other than going to the tribunal, and the tribunal in the present case said that not giving the opportunity to the assessee of cross-examination by the learned assessing officer and by the learned joint commissioner is against the principles of natural justice, and that opportunity being the vital part of the assessment, because the whole basis of addition was the statement of that person. So in the absence of cross-examining of the witness of the revenue on which the revenue was relying, the whole assessment proceedings and the whole addition does not have any leg to stand. So the addition was deleted by the tribunal. The crux of the theory is that the assessee was able to win his case because the assessee has repeatedly requested the revenue to provide the opportunity of cross-examination during the assessment proceedings, and from this case it is a takeaway that whenever there is some statement on the basis of which the revenue is going to make the addition of the assessee should ask the opportunity of cross-examining of that person. At the end of this video, once again, I am repeating the name of the case. The name of the case is Aragounder, Muthusamy versus Income Tax Officer, and this case has been reported in 114 ITR Tribunal, short notes 47, and the matter has been decided by Chennai ITAT, Chennai ITAT C bench on 9th August 2024. Thank you, friends.